Hello, everyone, and welcome to today's webinar presentation, Overtime, What Employers Need to Know Today. Classifying an employee's overtime exemption sounds like it would be simple. Are they salaried? However, as you'll see during today's event, it is so much more complex than just how an employee is paid. Before getting further into today's topic, I'd like to take a moment to introduce myself and my organization. My name is Zielinski, and I'm the Marketing Director for ComplianceHR. You may recognize my name from the email invitations you received for today's event. And just to prevent a couple of popular questions from entering the Q&A box, I'd like to let you all know that this presentation will be recorded and it will be emailed to everyone attending. So please keep an eye on your inbox for an email from ComplianceHR webinars. Now, a bit about ComplianceHR for anyone who may be unfamiliar. ComplianceHR is a joint venture between two incredible and innovative organizations, the AI technology company Navigator and the law firm Littler. ComplianceHR delivers expert employment law guidance in a fraction of the time. Our goal is to simplify the complexity of employment law. Again, something we will learn a lot about during today's event. To achieve that goal, ComplianceHR offers a suite of technology solutions around critical HR compliance topics, like employee overtime, independent contractor classification, employee handbooks, onboarding, leave, and many others. Today, before we start our presentation, I'd like to briefly introduce you to Navigator Overtime, or Navigator OT. This solution helps you quickly and compliantly determine the proper exemption status for an employee position. With an easy-to-use digital questionnaire that captures your specific fact pattern, actionable risk assessments driven by expert analysis, an instant actionable guidance, and a customized report that can help you lower your risk of misclassification. If you're interested in learning more, a survey should have just popped up on your screen. You may have to exit full screen mode to see it. If you'd like to receive a complimentary demo of the Navigator suite, simply answer yes, and I will send your contact information to our team of experts to have a deeper conversation with you about your compliance strategy and if our tools can help support it. In addition to a demonstration of our solutions, you may be eligible to receive a free trial of our products, so you can see precisely how much time and money they can save you. While the poll is running, I wanted to share just a bit more about how Navigator OT can support your organization as you prepare for the potential new overtime changes. With the simple questionnaire performing all applicable tests local to the position's jurisdictions and nationally, this solution can save you more than 90% of the time you would otherwise spend performing an employee overtime classification audit manually. So again, if you're interested in seeing these solutions, please select yes on the poll or click the link in the links panel. And of course, you can always visit our website too. Now I have the pleasure of announcing today's webinar presenters, David Jordan and Pierre Noebes. Pierre and David represent employers in a broad range of employment matters, including wage and hour law, making them both experts on today's topic. Pierre and David, thank you very much for your time today. I'll pass it over to you.
Thank you so much, Stephanie, and thank you everyone for joining Pierre and I today to talk about overtime. I know you can't imagine this, but it is one of my favorite topics to talk about overtime. We could spend an entire 8-hour course today talking about overtime under federal law, and then a number of state and local variations of overtime law. What we've decided to do today are to hit a number of high points about overtime. Exemptions, calculations of overtime, the new rules, how in the world does the election impact it? And we're going to talk about all those topics today. You may have lots of questions. We're going to try to answer a handful of those questions today. If we don't get to your question today, feel free to still ask it. We're actually going to download a list of every question, and me or Pierre or somebody else will take the time to reach back to you and answer your question. Regardless, you see our email addresses here. You're always welcome to reach out after the presentation, and we'll be happy to talk to you more about overtime, or frankly, anything you want to talk about. So let's start today about discrimination. Totally different than overtime. But I just want to sort of set the playing field. And I want to talk about the differences between discrimination litigation and overtime litigation. So a typical discrimination lawsuit involves one worker. We've got maybe some back wages due, maybe some front pay. You know, the typical exposure in a discrimination case is typically around $10,000 to $50,000. There's typically a punitive damage and emotional distress cap under Title VII of the Civil Rights Act under federal law. That's set at $300,000. You know, cases like this typically settle for, 5 to 25, maybe a little bit more in other jurisdictions. Impacts a few supervisors, a few employees, a few HR personnel. It's the employee's burden to prove it. There's typically a few depositions, a 2 to 3 day trial. But here's what I want you to think about. I want you to think about all of the resources your organization devotes to discrimination lawsuits. We've got sophisticated and trained HR departments around discrimination. We have risk managers and investigators that are constantly answering questions for employees, looking into disputes, resolving disputes. We have mandatory training, sometimes annual, that employees take over and over and over about discrimination and harassment in the workplace. Typically, these matters are insured. They fall under commercial policies, a rider we typically call EPLI. So even the risk we've talked about today is typically consumed by an insurance policy. And we devote hundreds and hundreds of hours in every workplace across America on discrimination and harassment. And look, extremely important issues. I am not one to say don't devote those hours. But what I want to tell you today is I think we ought to devote a similar number of hours to wage and hour compliance. And here's the typicality of an FLSA lawsuit. We have hundreds or maybe thousands of employees that are covered in one lawsuit. We've got potentially independent contractors, workers we didn't even think were employees, falling within these lawsuits. We've got exposure that can go back 3+ years, typically doubled for liquidated damages. You only need one employee to start a class or collective action under federal law. And the full exposure in these cases can be 7, 8, or 9 figures. I actually had a $545 million exposure case a handful of years ago. Cases like this don't settle for $5,000 to $25,000. They settle for 6 figures, 7 figures, even 8 figures. Attorneys' fees are automatic in these cases for the plaintiff's lawyers, and these attorneys on the other side know how to rack up millions in fees. And then the exemption burden is on the employer to prove. And the burden to keep records and keep time is on the employer. So why aren't companies devoting even more resources to wage and hour compliance? So when you're thinking about how to budget your dollars and time in your HR departments as you're planning out Q1 through Q4 on training and commitment to certain goals for your next 4 quarters, think about these issues when you're thinking about the time you want to invest in wage and hour compliance. Real briefly, I just want to talk about the types of liability we see in the wage and hour world. This topic today is about overtime. That's probably the leading area of compliance challenges in litigation, either misclassifying workers as exempt from overtime. You have managers or the company directing that you're not going to pay overtime in certain circumstances. We see that a lot in independent contractor misclassification. We've put workers in another non-employee box, and so we never pay overtime. We see lots of miscalculation of overtime cases. There's one calculation rule can impact thousands of employees, which makes class action treatment so easy. And it makes the math for the employee lawyers so easy in the courts. There are other types of wage and hour cases, minimum wage. Those don't happen very often. Most employees, even if you mess something up, are paid generally over minimum wage. There's also cases around not paying all the hours worked. But under federal law, that's only a problem if you didn't otherwise meet the minimum wage obligation or there was overtime worked. So we don't see a ton of those cases either. So largely it's overtime that drives the bus in terms of exposure and liability. Federal law looks back 3 years. It's a 2-year limitations period, and a 3rd year if your conduct was willful. And by the way, willfulness is not sort of I didn't know we were messing it up. Willfulness is you should have known what the law was and you didn't get it right, or someone told you the law was different, a lawyer, the head of HR, consultant, etc. But you know what? Something I want everyone to take away here is federal law is 3 years, but there are lots of states with longer limitations periods. And I don't have a slide for this because I could fill this whole hour up with slides about differences between state and federal law, but I'll just give you a few examples. You know, we've got Colorado that's got a 6-year limitations period. We have New Jersey that has a 6-year limitations period. We have Maine with a 6-year limitations period. Get this, in New Mexico, they claim, the plaintiff's lawyers and a few courts claim there's no limitations period. I don't even know what that means. That you can just go back forever? But that's the current working theory of the plaintiff side lawyers in New Mexico, is they can go back as far as they want under state law. So those are sort of the chief features of how overtime exposure works. We now are going to flip to briefly talking about exemptions, and I'll turn it over to Pierre.
Thanks, David. Really appreciate it. And just to add to some of the points that you were talking about too, in addition to the statute of limitations periods, the state laws also expand the liability as well. I know just anecdotally in Massachusetts, for example, there's treble damages. So you have 3 times the amount of damages can be applied in Massachusetts, just instead of the FLSA's liquidated double damages amount. So you've got 3 times the amount of damages under state law in Massachusetts. So you've got varying degrees of liability on top of varying degrees of statute of limitations applied as well. With respect to the overtime exemptions here, I want to start first with what's known as sort of thought of as the white collar exemptions. That is the executive, administrative, and professional exemptions here. These are the ones that are most commonly relied on by employers. And as a result of that, these are often the most commonly misunderstood and misapplied. While we'll sort of go into more detail on these a little later in the presentation, I want to highlight these exemptions that each of these require a minimum salary basis and the performance of certain exempt work. I want to note, particularly with the administrative exemption, that this is often relied on as sort of a big catch-all exemption, if you will. And it's a lot what companies rely on as, maybe they're executive, maybe they're professional. We'll stick this employee as an administrative employee because maybe they satisfy some of the executive, maybe they satisfy some of the professional requirements. We'll consider them or classify them as an administratively exempt employee. We'll discuss a little bit more during this presentation, but right now, David and I were talking about this a little bit earlier. It's a great time to take a look at those jobs where you have some of those trouble spots or any positions where you have a lot of incumbents, so where you've got a lot of employees, where you've got a lot of questions. In our experience, that's where you've got a lot of risk or where there can be some significant risk, and it's worth regularly auditing those positions, particularly for misclassification issues and ensuring that they are actually complying with the FLSA for overtime compliance. Moving next to the highly compensated exemption, these are the individuals where they need to be paid at a highly compensated level. It's right there in the name. Right now, these folks need to be paid at least $132,964 per year. Effective January 1, 2025, these folks will need to be paid $151,164 a year, and they will need to customarily and regularly perform any one or more of the exempt duties or responsibilities of one of the executive, administrative, or professional employee exemptions as well. Moving down, the computer exemption, excuse me, these employees are computer system analysts, computer programmers, software engineers, or other sort of similarly skilled workers in the computer field. Interestingly, these folks can be paid either on a salary or fee basis, but they can also be paid hourly. They do need, however, to be paid at least $27.63 an hour. Again, their primary duties, however, do need to consist of that sort of system analyst or computer, highly technical skilled computer work. The outside sales folks, this is perhaps one that most folks are familiar with. Where there are some issues, though, is what does it mean to actually be performing outside sales? I know that sounds so elementary, but it can be confusing, and it particularly was challenging for a lot of companies during COVID, where there were shelter-in-place rules or any number of different things, and in the era of work from home, that has become a big question for a lot of folks. But under the regulations, it is an outside salesperson is someone who is customarily and regularly engaged away from the employer's place or places of business in performing their sales duties. So that's making sales or obtaining orders or contracts. Moving down the list, the motor carrier exemption. So this, interestingly, is an overtime exemption only. So this does not exempt someone from the minimum wage requirements. This is someone who's employed by a motor carrier or a motor private carrier. This applies exclusively to drivers, driver helpers, loaders, or mechanics. For the retail sales 7I exemption, this is one that I, in my experience, have found a lot of companies struggle with because it deals with how folks are paid, and it requires that they be paid by more than half of their wages through commissions. So more than half of the employee's compensation for a representative period, and it has to be not less than 1 month. So that representative period, not less than 1 month, has to be commissions on goods or services, has to make up their entire pay. With that, they can then be exempt from overtime. Without that, they do not qualify for the exemption. As David mentioned earlier, all of these exemptions, the burden of proof to satisfy any of them falls on the employer. So it is not enough to just say, I think this works, it's fine. The employee has told me that they do all this exempt work. The employer must prove this up. If a plaintiff's lawyer or the Department of Labor comes knocking and says, employer, you must prove this out, the burden is on the employer to fully demonstrate it for each employee. It is not enough to just say, on the whole, folks generally satisfy these. It is for each employee that must fall within the classification and satisfy it. Of course, the trouble with all this is that not each state recognizes each of these exemptions. By way of quick example, Dave and I put together this chart to show for the highly compensated exemption. This is just a quick chart to show, not every state follows it. You've got here, states that you can reasonably rely on the highly compensated exemption, those that it's a little bit unclear, those states with their own state-specific exemption, and those where you absolutely cannot rely on the FLSA's highly compensated exemption. Turning next to this final slide before I turn it over to David, this is just to sort of talk about the compensation test and the duties test that you apply under the FLSA to determine whether someone qualifies for one of these exemptions. Just to briefly wrap this up before I turn it over to David, I wanted to give just a quick example, at least for the compensation test, to demonstrate how granular all of this can be. In the state of New York, for example, the state requires a weekly salary of $1,124.20 per week as of January 1, 2024. However, New York City, as well as Nassau, Suffolk, and Westchester counties, they require a weekly salary of $1,200. So employers can get easily tripped up, fall into all these traps, and it is imperative to be paying very, very close attention to what each of these states and each of these, in New York, for example, what every single place is requiring. So I'll turn it over to David to go a little bit further into all these.
Great. Thank you so much, Pierre. So let's talk about the minimum salary level. So we've got the compensation test, which requires salary level and a salary basis. And Pierre will talk a little bit about the salary basis and what that means for docking just a little bit. But the salary levels are required under the FLSA for an exemption, and every state has their own version of a salary level. As you know, for many, many years, we've been set at $684 a week until July 1 of 2024 this summer, when that moved to $844 a week, or approximately $44,000 a year. It has to be paid on a salary basis to maintain the exemption under the executive, administrative, or professional exemptions. Now, few exceptions to the salary level requirements. There's no compensation requirements for outside sales, doctors, lawyers, and teachers. All of those have their own sort of subset of rules around them that you should check on. Computer employees can be paid on an hourly basis instead of salary. You heard Pierre mention that. Commissioned employees don't have to be paid on a salary to fall under the 7I retail exemption. He mentioned that. And then some administrative and professional employees can be paid on a fee basis, way outside the scope of our discussion today. But there is a way to pay people on a fee as opposed to a weekly salary. But prior to July 1, we were at $684. Now we're at $844. The highly compensated exception as of now, as of November 2024, is currently $132,964. So that is the current state of play with regards to the salary levels. And those have all been in place since July 1. On January 1st of this year, the minimum salary level for the executive, administrative, and professional exemptions is scheduled to go up to $1,128 a week. That is $58,656 a year. The highly compensated exception, the one I just mentioned, goes all the way up to $151,164 per year. It wasn't that long ago, it was $100,000, and now we're at $151,000. Both those occur currently on January 1st. The salary level that we just talked about that goes into effect on July 1 and January 1 is also set to automatically increase every 3 years. So we're going to have to go through this exercise every single 3 years. Now, just so you know, that $58,000 a year is based on the 35th percentile of the lowest census region of full-time salary workers in the country. So they base it on basically the lowest ranking census. That's currently the South. By the way, the South also includes states like Virginia, so where there's a lot of highly paid people, but that's the DOL's definition of the South. And so if you imagine in 3 years, they'll look at what that 35th percentile is, and they'll fix a new salary level based on that 35th percentile. The same is done for the $151,000. That's set at the 85th percentile. So you could, I think, predict somewhat what those salary levels are going to go to every 3 years. You could reach out to us, in the year preceding and say, David and Pierre, where do you think this is likely to go? And we could kind of give you, I think, a relative guess as to what we think that 3-year number is going to go to. Now, there are multiple challenges in the Fifth Circuit right here in the great state of Texas. Thank you, Texas, to this January rule. And I think employers and trade associations still hope to stop the rule. There's actually a hearing scheduled tomorrow in the case of the state of Texas versus the Department of Labor at 10 a.m. That a lot of people will be paying attention to see how the court reacts to the request by the state of Texas to enjoin that January 1 rule. There are other cases currently pending as well, asking courts to enjoin the January 1 rule. If any of you remember back in 2016, at the very end of the Obama administration, there was a December 1 start date for the new salary level rules. And the day before Thanksgiving, I'm sure some of you are nodding, as everyone was driving to grandma's house, a court enjoined the December 1 rule. People had already made changes to their salary levels. Some companies ceased to a halt. The C-suite was freaking out. People were trying to reverse course. Employees had already been notified. It was a real mess. It was sort of ruined everyone's Thanksgiving in 2016. The same thing could happen here. It could be Christmas Day. Some court enters an order saying, look, we're going to stop this rule from going into effect. And then that last week of December, where everyone hopes to not work, you're trying to figure out what to do next. I think there very well could be a chance that we don't know what's going to happen until the end of December with regards to this January 1 rule. And I think that's unfortunate. But currently we're still under the Biden administration. There's no reason the Department of Labor is not going to continue to push these issues. And so it very well could be last minute. I think everyone is hopeful that we've learned from 2016 and the courts will try to rule sooner, as in like sometime in November. But just keep that in mind. There has been another development in the Fifth Circuit in a case called Mayfield versus the Department of Labor. They were looking at an earlier version of salary levels, and the Fifth Circuit said that the Department of Labor has the power to change salary levels. That's one of the arguments that employers have made in these current Texas cases, is that the DOL can't even have a salary level test under the Fair Labor Standards Act. The Fifth Circuit sort of settled that in September. So the arguments, I think, are more nuanced. I think that reduced the odds of them being overturned. So I think handicap it at maybe like a third, 30 to 40% chance that they're enjoined before January 1. So that's my current handicapping. But I do think there's still a risk that go into effect. I want to make one other point. Somebody who's on the call today called me this morning, asked me about this, and a few of you asked questions about the Trump administration and what's likely to happen here. The Trump administration is going to take over in early January. They will make, the Trump administration and the Department of Labor will make decisions as to what to do with the litigation. So if you imagine if a district court enjoins the litigation, the Department of Labor could sit on their hands and not appeal it. And we would end up with a regulation that essentially is not put into effect. So the Trump administration and how they react in January to the existing litigation could have some continued impact. I think we're reading tea leaves a little bit to make real guesses as to what the Trump administration is likely to do. Those decisions will be made by a White House staff, including career DOL, as well as appointed DOL folks. So, but I think there's a lot to pay attention to. I think what that really means is, like, what do we do to prepare? I think if you still haven't made any decisions as to what you're doing, I think you need a plan to change. Don't wait for the court rulings. Make the plans now. You can decide not to pull the trigger until the week before, or even the week of. But I would have a really good idea as to what you plan to do. Are you gonna increase people up to those salary levels? Are you gonna reclassify them as non-exempt? And you need to look at both folks that you need to get up to 58,656, or you need to look at people who may not meet all the duties required for the the EAP, the executive administrative professional, and have otherwise been exempt under the highly compensated, you may need to figure out how to get them up to the higher 151 number if you're not going to be able to justify, if you're not going to be able to hit all the job duties for those workers. Real quickly, sort of on the reclassification process, it doesn't necessarily have to cost you money. So you certainly can calculate the cost of increasing salary to the minimum salary levels. Like, clearly there's a cost there. You got to take a guy from 45 to 58. That's 13 grand a year. And you could also sort of leave them at their salary level now, or convert them to hourly and pay them for overtime beyond 40 hours. That's clearly a cost-sensitive maneuver too. The third option is the one at the bottom of this slide, and that is a cost-neutral solution. And that is, let's say a guy's earning $50,000 a year. You don't want to bump him up to 58. You can reverse the math to figure out what hourly rate would we pay this guy, such that when he works his average 20 hours of overtime, he still roughly makes $50,000 a year. That is permitted under federal law. And so you should consider this when you're thinking about what do we want to do. I think your internal clients ought to know that there are cost-neutral solutions to this reclassification process. Pierre, do you want to spend a few minutes sort of just talking about some of these duties with a little more detail?
Yeah, absolutely. And just quickly, thanks, David. With this slide, just wanted to highlight for you folks states where there's a higher salary level than the FLSA's minimum salary basis level. So you've got California, Washington, Colorado, Alaska, New York, and Maine. Of course, as a result of the election this week, there's really no telling what this map will look like in the next 2 years. It's going to be imperative for companies, employers to be paying extremely close attention to changes to state laws related to exemptions going forward. I also just quickly wanted to touch on deductions for exempt salary workers. Here you can see this is the list of permissible deductions for exempt salary workers. It's things like full day absences for personal reasons, bona fide sick leave pursuant to a bona fide sick leave policy, or FMLA leave, excuse me, an offset for jury or military pay, penalties for safety violations, disciplinary suspensions, or for the first or last week of work. I have represented, I truly cannot, I was thinking about it earlier, and I could recall a situation in which I was representing a company for during a DOL investigation. They had near perfect time and payroll records, and the one ding they had against them were their deductions for some of their salaried folks. And it was for things like folks taking a few hours off to go pick up their kids from school, or because they weren't feeling well, and they were docking a few hours worth of pay from their salaried folks. And that's where the DOL hit them the hardest, because that was the only thing they had against them. So this is just a major pitfall for a number of companies, because it's one of those things where you're not getting the full day of work out of your employee, but this is the list of deductions you've got. Moving right along, you heard David and I both talk about primary duties when it comes to what actually is the part of the test for an exempt employee. A primary duty is that principal, that main, the major. What is their most important part of their job? There really is no one set factor, and there is no clear bright line test, but part of the determination is to really look at what is the relative importance of the exempt duties. How much time are they spending performing the exempt work? How much freedom do they have from direct control? Are they able to sort of perform the duty autonomously? Are they able to do it sort of within their own discretion? And then what's the relationship between the employee's pay and other employees who are performing the same kind of non-exempt work? When it comes to primary duties, it's important to note that, a good sort of general rule, or at least an easy general rule to follow, at least when it comes to deciding whether an employee satisfies the primary duty test, is to consider whether the employee is spending 50% or more of their time performing exempt work. If they are spending 50% or more of their time performing exempt work, it's likely they will satisfy that primary duty test. Just quickly, by way of example, you'll notice in that second bullet there, you'll say the regulations do not require exempt employees to spend 50% or more of their time performing exempt work. To sort of highlight the differences between federal and state law, in California, state law actually does require an employee to spend 51% or more of their time performing work requiring knowledge of an advanced type to qualify for the professional exemption. So, just in state law, that's actually a requirement in California. So while federal law doesn't require it, state law does. Here, again, just to highlight, if it wasn't scary enough, that California example, here in Wisconsin, Iowa, Missouri, and Illinois, these states limit the amount of non-exempt work that exempt employees can do to only 20%. So it just, again, further examples of the differences between federal and state law when it comes to the overtime exemptions that apply. Moving right along, I know we talked about it briefly at the beginning, and so I'll move quickly through these slides here. But with respect to the executive exemption, the duties here, again, the primary duty focuses on the management of the enterprise. It is, what we would think of as, the executive, a management level employee. They've got the authority to hire or fire employees, or at least their suggestions or recommendations when it comes to hiring, firing, promotions, disciplinary actions, those sorts of things are given a particular type of weight. Important to note here, in that second bullet, you'll see that it says they are customarily or regularly directing the work of 2 or more other employees. I wanted to flag here that 2 or more other employees should also say the equivalent of 2 or more full-time employees. So that could be 4 part-time employees, that could be 1 full-time employee and 2 part-time employees. So it's not just that it's 2 employees, it is the equivalent of 2 full-time employees there. Next, again, the administrative exemption here, focusing on management or the general business operations of the employer. Again, they need to have that sort of discretion and independent judgment when it comes to actual matters of significance. So it's not just that, they've got control of somebody's calendar or something. It's that they have, meaningful decision-making authority, so to speak. The learned professional exemption, here it's a bit clearer, it's a bit more bright line. This is, somebody in the field of science or customary sort of, what you would think of somebody who is a learned professional. Doesn't necessarily require someone to have a license or certificate to be a learned professional. In some states, California, again, by way of example, you can satisfy this by having a license or certificate. Engineers, I just happen to know this from one of the companies I represent, field engineers or architects, you can satisfy that by the part of the test is if you are part of you have a certificate of being a certified with the state engineer or architect, that satisfies part of this test. Creative professional duties. So here, similar to the learned professional duties, in fact, part of that same exemption. Here, it's the primary duty of the employee. They're going to be working, it's part of their job to be working, in the field of invention, imagination. They're going to be, sort of using their skill and creativity to be developing something in an artistic or creative endeavor. Computer employees, I know we talked a little bit about this earlier. Again, it's going to be those system analysis techniques and procedures, folks who are doing, software and hardware development, system functions, specifications. They're designing and developing computer software and hardware. And then these outside sales exemption, again, primary duty. They're making sales, they're obtaining orders and contracts, and they're going to be engaged away from the employer's place of business while doing that making of sales and obtaining orders. Again, no salary requirement for these folks. That's part of the test. And David, I'll turn it over to you to wrap it up.
Sounds great. So let's talk about overtime itself for just a second, the sort of the calculation methodology. So first of all, the Fair Labor Standards Act does require that employers pay non-exempt employees the federal minimum wage for all hours worked, and this is the overtime piece, 1.5 times the employee's regular rates, not hourly rate, but regular rate of pay for hours worked over 40 in a work week. That's the basic rule under federal law. There are a number of states that have different rules. There are a number of states that have no overtime laws at all, like the great state of Texas, and many of these others. There are lots of other states. In fact, the balance of states not on this chart have an overtime law that essentially matches federal law. But there are a few states of note. There are 3 states that require daily overtime when you work more than 8 hours a day. That's Alaska, California, and Nevada. And there's 2 states that require daily overtime for working more than 12 hours in a day, and that's California and Colorado. The calculations of how to pay overtime in those states can get really messy, and it takes practice. And if you haven't done it often, you should practice. And we have a whole course where we train our associates on the calculation and methodology of overtime, and we spend like 3 hours doing math problems around calculating overtime in these situations. You should practice too. You should understand how your payroll company should be doing it. Let me make one other point. Some of you might be wondering, why do I care about California and Colorado and Nevada and Alaska? And let me make one really important point here. After COVID, companies had lost track of employees. Employees are all over the country. I have a Texas-only hospital system I represent, and they have more than 100 employees now located in 20-plus states across the country. They only have hospitals in Texas. So most companies, I think, now have figured out where their employees are located, but I think there's even some employers right now that still have no idea where their employees are actually located. And why does that matter? Because typically you apply the overtime rules of the state where the employee is sitting and doing their work. So if they are sitting in California on the beach working on a laptop for a Texas company, you're darn right those California overtime rules can apply. And if you're a company who never looked at California, you sort of denied California is even a state, like you're convinced it's another country, you're going to have to pay attention to those state rules where you have remote employees sitting. By the way, a quick plug for ComplianceHR and for Littler. This is a great reason to reach out to either ComplianceHR or Littler because we've sorted through all those rules. So don't hesitate to reach out if you're worried you have a remote employee sitting in a state and you have no idea whether the state or even the city or county has a rule that's going to affect that worker that's located there. One other point I'll make, these remote issues cause so much difficulty for some employers. They've actually prohibited employees from working remotely in certain states. Like, for example, you can work anywhere you want in the country except for California. Sorry, California, I don't mean to sort of harp on you, but that's an example of what some employers are doing, limiting states that employees can be remote. So let me talk about the regular, one other slide about premium pay. There are states that have premium pay requirements. In addition to the overtime requirements you see here, work on a 7th day in California and Kentucky does require premium pay. Massachusetts and Rhode Island also require premium pay for work on Sundays and work on holidays. So those additional premium pay requirements exist at the state level. Now, what is the regular rate? I told you have to pay 1.5 times the regular rate, not the hourly rate. The regular rate is all the remuneration for employment. I love that word, remuneration, paid to an employee in a work week divided by all the hours worked in the work week. That gives you what essentially their effective hourly rate is, what the DOL calls the regular rate. And you see here, I've got this really fancy equation here, hard to forget. I think the difficult part is what goes in the top and then what goes in the bottom. That's where I think a lot of companies get tripped up. Let's just talk about that briefly. Compensation that goes in the top includes all the hourly wages or salary. That's sort of easy enough to figure out. Commissions go in that top number. Non-discretionary team awards. If you hit this production goal, we'll give everybody $100. That means it goes in the top of that equation. Prizes and awards related to work. We will give you a prize if you meet these goals. Shift or job differentials, so you pay more for the third shift. Those differentials go in that top number. On-call pay goes in the top number. Gift cards. Seriously, gift cards? Yeah. If we're giving people gift cards for the work they perform, the value of those gift cards go in that top number. I listed RSUs here, restricted stock units. Typically, like health and welfare benefits fall outside this calculation. But there is a lot of litigation now across the country about RSUs and whether RSUs should fall into the regular rate calculation for non-exempt workers. If you offer RSUs to non-exempt workers, for the 2,000 people on this call, reach out to your labor and employment lawyer and talk through this issue with them. It is something that you ought to have on your radar. Now, what is excluded from that top number? You see here at the top, employee benefits like wellness programs, gym memberships, employee discounts. There's been some changes in the regulations over the last handful of years that have made this easier to exclude the value of those benefits from the overtime calculation. Payments for time not worked, right? Think about, for example, like PTO. Business expense reimbursements. So if they are for the employer's benefit, not the employee's benefit, you can exclude that from the calculation. So imagine, right, someone goes on a trip and they pay for the hotel room and you're going to reimburse them for that hotel room. That falls outside the calculation. But if you're reimbursing somebody for their commute to work is not for the employer benefit. It's non-compensable time. It's for the employee's benefit. You've got to put that commute stipend, right, in the calculation for the regular rate. Generally, premium pay, certain types of premium pay are excluded from the overtime calculation. This is a very complicated area. And when we do audits for companies and we look at their pay practices, we often find mistakes around these premium pay issues. Some types of premium pay are excludable, some types are not. So if you pay a premium for exceeding a normal workday, that could be excluded. If you pay somebody for time whenever they work more than 4 hours a day, that might not be excluded. In addition, not every state is the same. Colorado just confirmed this crazy rule that says that holiday pay premiums have to be included in the regular rate calculation. So we've never, in federal law and in nearly every other state, had to include holiday pay premiums in the calculation. But Colorado has jumped out on a ledge at the Supreme Court and said holiday pay under their statute has to be included. Holiday pay premiums have to be included in the overtime calculation. So stay tuned for more on that. If you have questions, we've got a whole Colorado office that is answering a ton of questions on this piece right now. Gifts for Christmas or other special occasions can be excluded. Discretionary team awards can be excluded. What I call sort of attaboys or pats on the back. Essentially, awards that nobody knew was coming. Think about somebody who had no idea that there was a $100 bonus that would be paid. If you did not incentivize them to do something, and you essentially surprise them with a gift, that's typically excludable from the overtime calculation. And then one last note I make here regarding the bottom number in that equation: vacation, sick, holiday hours do not count towards determining whether an employee worked more than 40 hours. Now, I'll add one point here. There are a number of employers that offer richer calculations than that. We see it a lot with collective bargaining agreements. We see it a lot in manufacturing, where they say your holiday is going to count towards your 40 hours. So you could actually only work 32 hours in a week, get 8 hours of holiday pay that you took off, and then work an extra shift and get paid overtime for that shift because the company has decided to calculate that holiday pay as hours worked. And that is permitted under federal law to count those hours if you want to do so. But that's not typically what employers do. I want to talk for a minute about what I call armoring and auditing. We've talked about a lot of stuff today. We've talked about the exemptions and how they work. We've talked about the salary levels. We've talked about the salary basis test. How do you mess up the salary by taking inappropriate deductions? We've talked about what's likely going to happen in a Trump administration. Is the salary level rule going to get thrown apart? We've talked about how to calculate the regular rate. But the very first thing we talked about today was litigation risk. You remember that $545 million problem for your company? What can we really do? What can you do, the 2,000 people listening right now, to help insulate what you're doing? The first is to audit your pay practices. Look at your job codes. Let me go to that slide. Look at your regular rate mathematics. Look at your pay codes. Do you have the right pay codes in the regular rate calculation? Companies will send me pay codes, and there'll be thousands of pay codes, and HR or payroll can often only decipher a handful of those pay codes and don't know what they do or why they go the direction they want. And we often spend a ton of time just cleaning up that regular rate calculation. So think about the math and think about the pay codes. Let me go back to the last slide. We'll talk about job descriptions for a minute. Job descriptions can really undermine your exemption. So you need to use job descriptions in a helpful way. You can imagine the job description that lists 100 duties, what I call micro duties. They may not take up very much time, but when you read them in a job description, it sure makes that employee look like they're non-exempt. When you write a job description for an exempt worker, you want to be clear that that job description illustrates the primary duty. Remember when Pierre talked about the most important duties? The job description should show that. Your most important duties are these 5 things. Sure, you may have to lift a box, and sure, you may have to, carry a filing cabinet, and sure, you may have to do some filing, but the most important duties are this. The duties for which you're going to spend more than half your time are these 5 things. That's how job descriptions should be written. We often read job descriptions, and they can really undermine your position in litigation. I think another way to armor yourself is to use self-assessments. Now think about this. We know what the exempt duties are. Pierre talked about each of the tests and the exempt duties within those, and there's a subset beneath those in the regulations. Imagine if your employee self-assessment said, David, give me 3 examples of how you used independent discretion in your job over the last year. That employee, filling out a self-assessment and knowing how great he is going to say, I don't have 3 examples, I've got 10 examples. And he's going to fill out that self-assessment, and he's going to bolster everything about his job so that when you go back in litigation and David says, hey, I was exempt, I was not exempt from overtime, I'm basically a glorified clerk, you're going to put that self-assessment in front of me and say, David, were you lying in your self-assessment? I mean, like, oh, maybe I wasn't lying, right? Remember, right? If the employee can fill out that self-assessment and the items that they're answering are related to those job duties that are required for the exemption, you'll have a much easier time establishing in litigation if that employee's job is indeed exempt. And the employee is going to have a more difficult time denying those exempt duties when he's got 5 years of history of self-assessments where he talked about how he regularly supervised 2 or more full-time employees and what he did with regards to that supervision. As you're thinking about these overtime exemptions and sort of what to do, just a few places to start. Like with only 8 weeks left, look at those folks that are paid $85,000 or so annually and less. Consider not just what's going to happen this year, but where you're going to be at in 3 years. Imagine, consider that 58 you put them at this year, after you give them a 5% increase next year, that's going to go up. And so think about, looking at everybody underneath a particular window. Look at people with unique compensation arrangements. You can sort people that have, just a few supervisors or a large number of similarly situated workers. So instead of focusing your time on the one help desk employee, if you're limited on time, focus on the 50 administrative assistants, right? Look at your exempt sales employees. Inside sales is very difficult to maintain the exemption, and they're often paid far less than the salary levels required. Make sure they're actually exempt, or make sure their duties are really outside sales as opposed to inside sales. Look at exempt workers with blue collar or manual duties. Those are often traps. And then think about whether remote work has changed the position profile since the last time you've looked at it. I would really encourage you, particularly given that these exemptions are going to continue to change periodically over the last 3 years, to bake in regular periodic audits every year. And you don't have to do the whole company every year. You can say, we're going to pick a division a quarter or a department a quarter. And every quarter you spend X number of hours auditing a group of people. ComplianceHR can really help with that as well, given some of the tools they have that allow you to run duties through the prism that ComplianceHR has developed with regards to grading exemptions. So that's what we have today. I see that I've answered a number of questions. I think there's probably still a good handful that we have not. We plan to respond later in the next few days or week to some of those questions we haven't answered. If you don't hear from us, reach out to Pierre and I. We'll be happy to help you, or your favorite Littler lawyer. And if I answered your question and I just left you with more questions, feel free to reach out and help you everywhere we can. So, Stephanie?
David and Pierre, thank you both so very much for providing us with this great overview of what employers need to know about employee overtime. We had over about 200 questions today coming in through the Q&A box. So like David said, they'll work through sorting through those and reach out. I'll also likely send a resource with our top and most asked questions. So please keep an eye out for that. Everyone will receive a recording and a copy of the slide deck from ComplianceHR webinars. and it should come in the next couple of days. I'd like to offer another opportunity for our attendees today to register for a demonstration of the Navigator suite. As we just heard, this area of employment law has seen many changes lately, with likely more to come. So with over 200 questions during the event, it only emphasizes the complexity of and the uncertainty around employee overtime. With all of these possible pitfalls of overtime classification, it's critical you don't leave your compliance strategy up to chance. So please, if you're interested in a demo of our solutions or just chatting with our team, select yes on the poll or send us an email. And with that, thank you all again for attending. I know it's a busy, busy time of the year, so we appreciate you carving out an hour to join us. David and Pierre, you did a phenomenal job. Thank you so much. I hope you all have a great day.